Hello, this is Jason English. I'm an estate planning attorney in Austin, Texas, and I understand that you have an upcoming consultation scheduled with either me or a member of my team, and I wanted to reach out briefly before we meet. Many of the people we speak to tell us that they feel confused or even overwhelmed when it comes to estate planning, and that's completely normal. There are a lot of moving parts, and most people just want to make sure that they're making the right decisions for their family. And what we found over the years is when we provide a little bit of helpful information ahead of time, it makes the entire process feel clearer and much easier. It allows our consultation to be more productive and focused on your goals rather than starting from square one. We also want to remind you that estate planning, it's not about a bunch of documents, but it's about putting the right plan in place to get the outcome you want for your loved ones and avoid a bad outcome. The number one problem we've seen in 25 years of doing this, it's not bad people, not careless people, but it's good people, smart people, people who love their families. They all know that estate planning is important, and that's why you're here right now. You've already thought about it. You've asked yourself, who would take care of my kids? Who would make medical decisions for me if I can't? Who would pay the bills? Who makes sure that my home and my money go where I want? Conceptually, you get it. But here's the reality. Roughly 70% of people have no plan at all. None. And we see the other side of this statistic every single week. Families sitting in our office saying, we meant to do it, we talked about it, we just never got around to it. Good intentions. They don't protect your family. An estate plan with the right documents does. Clear decisions do. So the real question we're diving into today is this. How do you make sure your family is not left powerless? How do you make sure you haven't left a legal mess if you die unexpectedly? How do you plan for the ideal outcome and avoid a bad outcome? Let's start with what happens if you do nothing, because this is where most confusion lives. The first myth we need to bust. Your home does not automatically go to your spouse in Texas. A lot of people believe that. They bought the home together, both names are on it, and they assume if one of us dies, it just goes to the other. But Texas does not automatically do that for you. What usually happens? It doesn't show up right away. It shows up later. You try to refinance it, you try to sell it, and the title company runs a deeper search and says, wait a minute, your spouse passed away. There's no probate, there's no documentation transferring their interest. Now you have a problem. And here's where it gets worse. We see this all the time. Dad passes away, mom does nothing, 10 years go by, then mom passes away, and the adult kids come in and say, Mom passed, we need to sell the house. And we look at the record and say, your dad passed away 10 years ago, but nothing was done. Now we don't have one probate problem, we have two. And if dad had a will, but no one probated it within 4 years, now we may not even be able to use it. And that's how small delays, they turn into big messes. Now let's talk about blended families. And this is where things get very real, and we see this all the time. Let's say someone had children from a previous relationship, then they remarry. No will, or a will that wasn't probated within 4 years, and no plan. Under Texas law, the deceased parent's share can go directly to their biological children, not automatically to the surviving spouse. So you can have a situation where the husband dies and the wife is still living in the home, but now part of that property interest legally belongs to his children from a previous relationship. Now imagine the tension. And that's not something that families plan for, that's something they stumble into, and it's completely avoidable. Now let's shift to incapacity planning, because planning isn't just about death, it's about life. And if something happens to you, say stroke, accident, dementia, brain injury, who makes decisions? In Texas, we strongly recommend a living will, also called an advance directive. This is where you say, do you want life-sustaining treatment? Do you not? And you get to make that choice now, and not your kids in a hospital hallway under stress, deciding whether or not to leave you on life support or to pull the plug. There are also two key powers of attorney. One is a medical power of attorney, talking about who makes healthcare decisions if you can't. The other is a financial power of attorney, talking about who can access accounts, pay bills, deal with property. And here's something that people can forget is a HIPAA authorization. And without it, even your chosen decision maker may struggle to get medical information. And so you're adding clarity, you're removing barriers. Another powerful document, it's a declaration of guardian. And this one surprises people because it's not about your kids, it's about you. If something severe and permanent happens and a court must appoint a guardian, you can tell the judge, if I'm ever in that position, here's who I want. And just as important, here is who I absolutely do not want. And that matters. We hear all the time. It's just not about who should step in, it's also who shouldn't. Now let's talk about probate. Because people say, I just want to avoid probate. And then you ask, what is probate? And they say, I'm not really sure. Well, probate, it's court oversight. And so when someone dies, the court oversees the transfer of their assets. Even with a will, yes, even with a will. A will must still go through probate court. And that surprises a lot of people. Now, there are ways to avoid probate. Yes, in the most comprehensive way, a revocable living trust. And no, this is not just for the ultra wealthy. You definitely do not need a top hat or a monocle to get a revocable living trust. A living trust, it says the same thing that a will says. It says who gets what, who's in charge. It names guardians for your kids, but it changes how things are transferred. Revocable, it means that you can change it. Living means that it exists right now. You create it. And then after you create it, you connect your assets to it. And when properly funded, there is no probate court. There's no court approval before acting, no probate legal fees, no court delays. It speeds things up. And it also protects privacy. Because here's something else most people don't realize. But will, it's in the public record. And so there's an inventory of your assets that also gets in the public record. Who gets what? It's in the public record. Some people don't care, but others absolutely do. And here's another big one. If you own property in another state with a will or no plan, your family, they may need to open probate in each state in which you own real estate. So we're talking about a Texas probate, maybe an Arizona probate, a California probate, multiple courts with multiple attorneys and multiple fees. But with a properly structured living trust, you can avoid that. You need to consider something else if you don't have any type of plan or even with the will-based plan. And we're talking about our area probate courts. In Travis County, we have 2 probate courts. And if you consider how the population has grown over the last 20 years, there's more people and we have a limited court system. And so that means cases can pile up, delays can increase. And when someone dies, the family isn't thinking, I love my government oversight with probate. No, they're grieving and they want closure. They want to sell the home and access accounts. They want to wrap things up and move forward. And if there's no plan at all, and you're going through an heirship proceeding, 9 months just to get started, that's an eternity in talking about grief and time. Let's compare your 3 main options. Option 1, it's the state of Texas plan. That's where you do nothing. So what would your legal fees be? Well, to do an heirship for someone that has not had any sort of plan, I would assume it's probably around $7,000 per person who died without any plan. And if you're talking about a married couple, well, you can do the math. Multiply that times 2. And that's in today's dollars. And what's it going to be 10 years from now? Who knows? Time to begin accessing assets? About 9 months. And you don't decide how things go. The law does. Option 2, a will-based plan. Yes, it still goes through probate, but it makes probate much smoother. And you get to pick who gets what. What are typical probates cost with a clean will? Well, today they're around $5,000 for a person who died with a will. And it's definitely faster than if you had no will. It may be 3 months to get started. You get to decide who gets what. You decide guarding for kids, but it's still public and it's still court involved. Option 3, the revocable living trust plan. Court fees? None. Court delays? None. Privacy? Yes. You decide everything. It stays out of the public record. You know, the upfront cost is higher because there's more work, there's more documents, more guidance. But if you think of in terms of return on investment, it saves far more than what it costs. And yes, you still have a will with the trust-based plan, but it's that pour-over will. It catches anything that you forgot to move into the trust, but our goal is to never use it, and it's a safety net. So what have we really discovered today? That putting a plan in place is critical. You know, this is the final chapter of your story. You get to decide how it reads. Do you want court delays, extra expenses, family confusion, possible conflict, or do you want clarity, protection, efficiency, and privacy? This is one of the last acts of love that you can give your family. You can leave them with a mess, or you can leave them with a plan. One creates stress, the other one creates peace. And that choice, it's completely in your hands. We're looking forward to speaking with you and helping you move forward to the outcome that you want for your loved ones.